Hello and welcome everyone to the Polity Primer series of Drishti IAS English. My name is Pragya. So in the previous episode of Polity Primer, we were discussing the 102nd Constitutional Amendment Act, in which it gave the constitutional status to the National Commission for Backward Classes. And in our today's very interesting episode, we are going to discuss yet another landmark Constitutional Amendment Act, and that is the 103rd Constitutional Amendment Act, which has provided the reservation to the economically weaker sections of the society. So in this discussion, we are firstly going to study about what is the 103rd Constitutional Amendment all about. Then we are also going to examine the constitutional changes that have been introduced by this constitutional amendment in our Indian Constitution. Then we are also going to see the Supreme Court judgment in which the constitutional validity of the 103rd Constitutional Amendment Act has been upheld by the Honorable Supreme Court of India. And lastly, we are going to discuss some of the important questions from the perspective of your prelims examination. So if I talk about the background of our today's topic, so the Honorable Supreme Court of India in the landmark case of Janhit Abhiyan versus Union of India has upheld the constitutional validity of the 103rd Constitutional Amendment Act. The Supreme Court recognized that yes, this was a case of reasonable classification and the state has extended its affirmative action policy to those people who are economically weaker in the society, and they are also entitled to the reservation policies of the government. So this brings us to the moot point of discussion of our today's section, that what exactly is the 103rd Constitutional Amendment Act. So we are all aware that the Government of India follows a affirmative action policy. Affirmative action policy. And what is this affirmative action policy? So see, let us understand this very simply, that there are some unequals amongst the equals. So Article 14 provides us right to equality, and it is a fundamental right, but it is very unfair to treat those unequals as equals. Okay, we need to give them a level playing field first, and this is ensured by the affirmative action policy of the Government of India. So this 103rd Constitutional Amendment Act is an epitome of the affirmative action policy, and this has extended 10% reservation to the EWS section, that is the economically weaker section of the society. And this is in addition to the existing reservations for the scheduled castes, scheduled tribes and the other backward classes of community. So basically through this reservation, the government has tried to fulfill its obligation under Article 46 of the Constitution of India. So what is this Article 46? It says that the government has a special responsibility to take care of those sections of the society who are educationally as well as economically weaker. Okay, and that is what the Government of India has tried to fulfill, the responsibility that is enshrined under Article 46 of our Indian Constitution to by finally giving this 10% reservation to the economically weaker section of the society. Moving forward. So what is the criteria for the EWS reservation? The annual income of the person should be less than rupees 8 lakh, and this is the gross household income. It should not be more than rupees 8 lakh. Okay. The person should not own more than 5 acres of agricultural land. People who have a house but less than 1000 square feet in a town, residential plot of less than 100 square yards in the notified municipalities, and residential plot of less than 200 square yards in areas other than the notified municipalities. And these people are categorized as EWS, or the economically weaker sections in the society. Moving forward, let us examine the constitutional provisions or the constitutional changes that has been introduced by the 103rd Constitutional Amendment Act in our Indian Constitution. So it has added a new article, namely Article 15 Clause 6. So Article 15 Clause 6 has been introduced to extend reservations to economically disadvantaged sections for admissions into educational institutions, encompassing both private educational institutions, whether supported or unsupported by the government, except for minority educational institutions mentioned in clause 1 of Article 30. And not only this, this also extends the reservation in government jobs. Okay, so this is at par with the reservation that is given to the SC, ST and OBC community, that yes, they are entitled for reservation in educational institutions as well as in government jobs. Moving forward, it has also added Article 16 Clause 6 in our Indian Constitution, which provides them reservation in the government post. An explanation states that economic weakness shall be decided on the basis of family income and other indicators of economic disadvantage. So basically this is a reasonable classification. Reasonable classification that has been made in the favor of those people who come from the economically disadvantaged section of the society. So two new articles have been added. Okay, Article 15 subclause 6 has been added and Article 16 subclause 6 has been added, so as to facilitate them reservations in educational institutions, whether private or government, and as well as in government jobs. Moving forward, let us examine the Supreme Court judgment, and the grounds of the challenge were the petitioners in this case, Janhit Abhiyan versus Union of India, were arguing that firstly, this 103rd Constitutional Amendment Act violates our basic structure. So we all know that the basic structure doctrine was evolved by the Honorable Supreme Court in the Keshwanand Bharti case, and the petitioners in this case were arguing that it violates the basic structure. How? Because it provides reservation solely on economic criteria. And affirmative action policies are made for only for those people who have been socially disadvantaged. So that is why it is in violation of this basic structure doctrine, because it makes classification based solely on the economic criteria. But the Supreme Court in this Janhit Abhiyan versus Union of India case held by a 3:2 majority the validity of the 103rd Constitutional Amendment. It said that no, it is completely valid in nature. It is completely constitutional in nature. So basically, the Supreme Court held that reservation was an instrument of affirmative action by the state and should not be confined to the SCs, STs, SEBCs, that is the socially and educationally backward classes, and the non-creamy layer of the OBCs, but also include any class or sections so disadvantaged as to answer the description of weaker section. That means the Supreme Court in this case held the economic criteria for creating the classification as valid. Okay, so what is this reasonable classification under Article 14? It says that it is based on the principle known as intelligible differentia. Intelligible differentia. So what is this doctrine of intelligible differentia? It says that if you are excluding a group from a classification, you should have a reasonable justification for that. You should have a intelligible differentia for that, that justifies that exclusion. Okay, and in this case the central government argued that yes, they are economically very weak in nature, so why should the affirmative action policy that we are giving to the other socially disadvantaged group not extend to them? What is their fault just because they are in general category? Is this their only fault? So the central government was arguing on these lines, and the Supreme Court held that yes, it is a reasonable classification because you can be disadvantaged on economic grounds as well, and the central government, as I said, is obligated to take care of both educationally and economically weaker sections in the society. So our Chief Justice of India at that point of time was also in the majority opinion, and the EWS quota was finally held to be constitutionally valid because it created a reasonable classification in favor of the economically disadvantaged group. It also made a correct, linkage to the objective of the act, that yes, it is an affirmative action policy. So it fulfilled the double proportionality test. And what is this double proportionality test that has been evolved under Article 14 of our Indian Constitution? The test of intelligible differentia, and it should have a rational nexus to the object that was to be achieved by the act. Okay, so in this case, both of these points were proved by the central government in their favor, and that is why the Supreme Court said that no, affirmative action policy cannot be limited. Okay, it has to be granted to those people who are actually deserving of that benefit. But the minority opinion said that no, it will create further compartmentalization. So this is the summary of the Supreme Court judgment in this case. Okay, so on the question of whether reservation on the sole basis of economic criteria violates the basic structure of our Indian Constitution, the majority view was reservation singularly on economic criterion does not violate the basic structure. It is an instrument of affirmative action by the state for an egalitarian society. So this was the majority opinion. Okay, and the minority view was reservation is a powerful tool to enable equal opportunity and equal access. Introducing economic basis is permissible, yet the othering of socially and educationally disadvantaged class will amount to heaping injustice based on their past disability. So this was their minority view, that okay, you are excluding the SCs, SCs, STs, SEBCs and the OBCs. So basically you are trying to inflict again the damage which has been done to them historically. You are trying to exclude them just because of their past inability. So that is why it is not providing any kind of equal opportunity, because you should have included those sections of the society as well who are economically weaker in the SCs, STs and OBCs etc. as well. Okay, so this was the minority view. Then on the question of whether EWS quota breaches the ceiling limit of 50% on reservation, the majority view was it does not breach the ceiling limit, which is not inflexible and applies only to SC, ST, OBC and SEBC. So this 50% ceiling was evolved by the Honorable Supreme Court in the Indra Sohani case. And this is a landmark decision of the Honorable Supreme Court on the issue of reservation, that any reservation policy cannot breach the 50% ceiling. Okay, and that is why you see in any kind of government exam notification 50% seats are reserved and 50% seats are open for the general category. But now in that category we have created a special category known as the EWS, and they are also entitled to the 10% reservation. The government's argument was we are increasing the seats. Okay, we will create more educational institution, will increase the seats, and hence it will not breach the 50% ceiling, which was upheld by the Honorable Supreme Court in this case as well, that it is not inflexible in nature, but it has again opened a Pandora box. Okay, so this judgment can be cited to grant reservation to other sections of the society as well. Okay, minority view was this only, that permitting the breach will become a gateway for further infractions and result in compartmentalization of the reservation policy. With this, we come to a conclusion of our today's discussion. We have discussed the 103rd Constitutional Amendment Act. We have also seen the constitutional changes that have been introduced in our Indian Constitution through this amendment. We have also seen the Supreme Court judgment in the Janhit Abhiyan versus Union of India, in which by a 3:2 majority, the Honorable Supreme Court has upheld the validity of this 103rd Constitutional Amendment Act. So let us proceed further and discuss the previous practice question which I asked you in my previous session. So the question was, consider the following statements. So statement number 1 was, NCBC is a constitutional body. Your statement number 2 was, Shri Hansraj Gagan Ram Ahir is the current chairperson of NCBC. So which of the statements given above is are correct? Your options are 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So your correct answer definitely is going to be option C. Both of these statements are correct. NCBC is a constitutional body after the enactment of the 102nd Constitutional Amendment Act, and Shri Hansraj Gangaram Ahir is the current chairman of NCBC. Moving forward, let us discuss some of the important practice questions from our today's session. So the question is, consider the following statement. Your statement number 1 is, 103rd Constitutional Amendment granted 10% reservation to the economically weaker sections of the society. Your statement number 2 is, it inserted articles 15 clause 6 and 16 clause 6 in the Indian Constitution. So which of the statements given above is are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So your correct answer again is going to be option C. Both of these statements are correct. Now let us discuss the last question of our today's session. So the question is, consider the following statements, and this is a PYQ that has been asked in the year 2020. So the statement number 1 is, the Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Your statement number 2 is, the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. So which of the statements given above is are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So kindly drop your answers in the comment box below. I hope this session was insightful for you. If you have any feedback regarding the session, you can give it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.